For a trader, a business dispute is really just a legal matter. When a case remains unresolved for years, money can be tied up, business relationships can break down, and some companies may struggle to survive.
The commercial court has a total of 7,480 commercial court cases pending before the judges. Of these, 1,424 are in the trade, construction and corporation cluster. The trade cases are the biggest number of cases that we have through in the commercial court.
It is one of the reasons the judiciary is encouraging greater use of alternative dispute resolution, ADR, in trade and commercial disputes.
Commercial justice is essential for economic health. It influences capital flow, project development, employment, and infrastructure. Disputes unresolved cause costs like tied up capital, damaged relationships, higher project costs, and eroded trust. Effective dispute resolution is therefore key to a healthy economy. ADR is therefore viewed by the judiciary as one of the ways of reducing case backlog and thus stimulating economic activity.
ADR allows parties to resolve disputes through mechanisms such as mediation and arbitration rather than going through a lengthy court process. Supporters say it can be quicker, less costly and less adversarial, particularly for businesses that need to preserve commercial relationships.
35% of what Uganda Revenue Authority collected against their collection of 31.6 trillion. 35% of that came from trade. That means traders are very key enablers and drivers to this economy. The disputes of traders are something that the judicial leadership, the CJ, the CJPJ, are saying we need to have these resolved through ADR.
But traders say the challenge is not only the time taken to resolve disputes. They also point to the rising cost of litigation and concerns over some disputes involving the Uganda Revenue Authority, saying they can struggle to get timely justice.
We have the Tax Appeals Tribunal, for example, as one way of owning a dispute before it goes to adjudication. But one, you must have a 30% deposit before you sit into that. If it is $1 billion, 300 million need to be paid. This gives an upper hand to the levy collector. If the intention was to collect 300 million, they already have it. Why would they go into any mediation of any kind?
For a business already operating on tight margins, prolonged litigation can have serious consequences, and that is why traders want commercial cases handled more quickly, arguing that justice delayed can become a threat to the very businesses the justice system is meant to protect.
You find a brilliant business making money, profitable, but they end up in court for whatever reason, and 4 years, 5 years, 10 years, we are in court, and you find that only the cost of interest that these people are paying in banks crumbles the entire business. The failure to service the customer base, you find new players coming into the market. Now, this dynamics is not appreciated by the judiciary system.
The judiciary says strengthening ADR could help reduce the burden on courts while giving businesses another avenue to resolve disputes.
Our strategy at the commercial division to enhance ADR is that no mediation, there's no hearing date. So all cases that are filed at the commercial court are filed with mediation causes.
The bigger question now is whether ADR can become more than an alternative and become a faster, more accessible route to commercial justice. For Uganda's traders, the stakes are high, because when a business dispute takes years to resolve, it is not only a case that is waiting, a business may be waiting to survive. Daniel Kibet, NTV.